Hello, friends. Welcome back to the Liberty Weekly podcast. I'm your host, as always, Patrick McFarlane. This is episode 127, and the show notes may be found at libertyweekly.net/127. If you've been paying attention over the past several months, I think it's been 3 or 4, I've been on a hiatus, and I strongly, very seriously considered wrapping the show up. However, I just could not bring myself to do it, and so everything stayed idle, including the website and the podcast feed for, like I said, 3 or 4 months. I recorded several episode 127s and released some of them, so I know that some of you downloaded them. However, I was not comfortable with some of the content in it, and so I decided to pull those. However, they are still available in full for my Patreon subscribers at patreon.com/Liberty Weekly. I think they're good episodes. One was about Trump derangement syndrome, and another one was about the Sarah McCandless murder trial that happened in the county next door to me in Wisconsin. And it included a lot of people that I've practiced with in the legal community, and I knew a bunch about it. And I had practiced in front of the judge that this case was in front of. And if you don't know this was a murder case that happened in Wisconsin. It was on court TV. It was live streamed, the whole thing, in the courtroom. And it was kind of captivated people around here. And so I did a deep dive on it and my analysis and my legal opinion on these certain things. So I found that it was a lot of fun to do. And I think that, if I may say so myself, I think that my coverage rivaled Court TV's coverage, and I think I did a better job in many instances of talking about the case and analyzing it and giving, what the case was about and why I think there's Me Too things at play here, and kind of the jury rejected this Me Too. And so I think it's a pretty good content. And if you want to check that out, that's at patreon.com/Liberty Weekly. $3 a month will get you the audio version, and $5 a month will get you the video version. And there's a whole archive of Liberty Weekly bonuses that go back there. I know once I had announced that I was closing up the show, I lost a few patrons, and I completely understand that. But I'm to the point where I'm not breaking into the black anymore because of that. And so hopefully some of y'all come back now that I start releasing with some regularity. But hold me to it. I mean, don't just join. Wait till I've put out a few episodes on a regular basis. So I don't want to take up too much time before I get into the content. Today, I'm going to be talking about Murray Rothbard's Punishment and Proportionality chapter in The Ethics of Liberty. But I do want to give a roadmap as to what the show is going to be from this point forward for the next little bit here. So I've really thought about what the different niches are of the libertarian podcasts out there. I like to think that I'm one of the better libertarian podcasts out there, even though I have a small audience, or a smaller audience compared to the AAA shows, as I like to call them. But in thinking about all the shows that I enjoy the most, I keep thinking about how they all, division of labor, how they all have their little role to play. And I've really gone in lots of different places with the show. But I've never seen myself as an interviewer. And in fact, although I have great interviews that I've really enjoyed, I feel like, well, other people have really great guests all the time. And it's hard to compete with that, especially when you keep seeing these recurring faces over and over again. So I don't just want to be an interview show. And the shows that I've done that I appreciate the most, and that's just me, it's really kind of more about what the audience likes, but the episodes I've liked, and I think the episodes that have been most useful to the libertarian community, are the episodes where I really go into legal theory and really kind of talk about that and share some interesting thoughts about it. So from this point forward, what I'm going to be doing, the release schedule I'd like to meet is releasing one episode every 2 weeks, and on the off week, publishing a Keith Knight interview, because, what I just said about all the, familiar faces that you see being interviewed around the libertarian podcasts. Well, I think that Keith brings the most, some of the biggest, most interesting faces. And I think that Keith is one of the best interviewers out there. I think very highly of Keith. He's the co-host to this show, and I think him and I have a lot of chemistry. And so it's been great being friends with Keith for the last few years. And he's just a dynamo, and I can't say enough good things about him. And he's a wonderful person to boot. So now that I'm done gushing about Keith, and maybe, I don't know if he'll listen to this or not, but so Keith is a great guy, and I haven't been utilizing him as much, and furthermore, putting out his episodes, because he has wonderful work, and that's Keith Knight, Don't Tread on Anyone. I'll put that link in the show notes page. He has a tremendous YouTube channel, talks to a whole bunch of people, incredibly intelligent, well-read person, if you don't know Keith, if you haven't listened to some of his episodes on this show, or if you're new. And I think that people have been trickling into the show, even while I haven't been publishing, and people have been listening to the deep tracks, which I really do appreciate. And that's so wonderful. So, at least we're back for the time being, and I'm looking forward to doing this next run, and getting in the rhythm furthermore, and putting out content regularly, and making some more real contributions to the theory, and explaining this all to you guys. So this is an audio only episode. I'm going to ease myself back into it, and I might start to tackle video again. But what I'll really just be doing is on the screen having up chapter 13 of The Ethics of Liberty and talking about it. I was going to be talking about Bruce L. Benson's essay in the Journal of Libertarian Studies that talked about taking Rothbard's punishment and proportionality theory and how to transition the current legal system into that model, and how it would be better, of course, critiquing Rothbard's theory just a little bit, but ultimately saying it's the correct one, but backstopping it quite a bit, and talking about how the closest thing in modern times that we have to this restitution-based system is in Japan. And this is something I studied in law school. I had a class my 3L year, it was spring semester of my third year in law school, the last semester. And so I can't sit here and say that I really paid the most attention. Plus my professor, rest his soul because he did pass away. But he was a flaming liberal and liked to spend most of the class talking about, you know, the things, Trump derangement things, and the things that progressives and liberals like to do. But that doesn't mean he wasn't intelligent and didn't have tremendous, tremendous work history to behind him. And so I think it was a useful class, and I learned a lot of things about Japanese law and Japanese culture. However, I didn't necessarily glean the most that I could have from that class, because I had other things on my mind in the last semester. But I did write a paper that it was an essay that I'm not incredibly proud of. I think I got like a B on it in the class, talking about this restitution-based theory. So maybe I'll put that in, if I can find it, I'll throw that off to the patrons, for all the patrons. I think so you can join at $1 per month, $3 and $5 and $10 and $20 and $50 and $100, I think. So, but to start out, Murray Rothbard talks about how the theory of punishment is an underdeveloped area of the libertarian legal theory. So we usually talk about how libertarians, how the non-aggression principle is king, and how no one can aggress against any other person. But Rothbard says it is very underdeveloped what sanctions may be taken against someone who invades private property rights. So in this there's a lot of legal theory behind the fact that in torts, usually what you have a right to be compensated. If someone injures you, you have a right to be compensated and made whole, is what they say, to put you in a position as you were before the accident, to make it as if the accident didn't really happen. Of course, you could have an amputated leg. There's only so much compensation that they can give you to that. But that is this theory of proportionality. That is that a tortfeasor or a criminal loses his own rights to the extent that he deprives another of their rights. And that's because basically, if you go beyond the proportionality of how much you were wronged, you then become the aggressor. I think that's pretty clear. And Rothbard only really touches on this, but he says that in a libertarian society, there are only two parties to a dispute or action at law, the victim or plaintiff and the alleged criminal or defendant. It is the plaintiff that presses charges in the courts against the wrongdoer. In a libertarian world, there would be no crimes against an ill-defined society, and therefore no such person as a district attorney who decides on a charge and then presses those charges against an alleged criminal. The proportionality rule tells us how much punishment a plaintiff may exact from a convicted wrongdoer and no more. It imposes the maximum limit on punishment that may be inflicted before the punisher himself becomes a criminal aggressor. So, as I said, but this utilitarian idea of protecting society or preventing future crime, which they're not very good at. So related back to this idea of proportionality, in the modern system, it doesn't seem that in a criminal case, any of the victim's rights would be restored. And it doesn't happen like as a de facto in the real world. It isn't very often that there's restitution ordered. And restitution is not good at compensating for the intangible loss of property, the loss of peace of mind, like psychological losses, or the intangible of having your home invaded. So if someone breaks into your home, for example, and doesn't steal anything, but you walk downstairs and see them standing in your living room, and let's say you don't have a gun and they run and get away, well, there's the emotional damages that you have of having your privacy and security disturbed that the criminal courts are just not good at all. And of course, you'd have to prove your damages. Like if that was a civil case, you'd have to prove your damages by introducing evidence of counseling sessions and maybe having the counselor's notes be admitted into evidence, or having the counselor testify, what have you, just to affirm that, yes, my client has PTSD. Because anyways, not to get off on a tangent there, but it's often said, and at the end of paragraph 2, Rothbard talks about how the only crime of capital, if capital punishment is ever allowed in a libertarian society, the only crime that it could ever be instituted as a punishment for would be murder. So you'll often hear from people who critique libertarian theory or propertarianism is they'll argue that, well, in a libertarian society, someone could come and steal something from your store and you'd be able to shoot them in the head. And like, say someone steals a candy bar from your store and you get to shoot them in the head. Well, no, that's not the case. And I think it gets tricky there because in the second paragraph, he says, or the third paragraph, Rothbard says on page 85, it would not be permissible then for a merchant whose bubblegum had been stolen to execute the convicted bubblegum thief. If he did so, then he, the merchant, would be an unjustifiable murderer who could be brought to the bar of justice by the heirs or assigns of the bubblegum thief. Well, it gets tricky then. Can you shoot shoplifters? I'd say no, you can't shoot shoplifters if... I guess it doesn't get too tricky, because if someone comes into your store with wielding a deadly weapon and you fear for your life, you can justifiably and shoot them in self-defense and kill them. And I suppose that would be fine under the libertarian legal theory if they're threatening your life. I think that's the key. But I do think it gets, if someone comes into your store and steals a substantial piece of merchandise that threatens your entire livelihood and you'll become destitute, it gets more tricky then, whether or not you can shoot them. And we could go on all day about that. So moving on, though, on the top of page 86, Rothbard says that, just as this proportionality, the maximum punishment, it's not a compulsion, and it's an option. And the plaintiff or the victim would have the ability to voluntarily forgive the victim of all or part of this penalty. If the victim rather wanted the defendant, the convicted wrongdoer, the convicted criminal, rather to pay them the restitution and to evade punishment of any kind. And it's a debate as to what this would be in a libertarian society, as to whether there'd be prison or anything like that. But at least the plaintiff would have the option of receiving payment and forgiving the criminal of their crime. But then Rothbard identifies a potential problem in terms of the case of murder, since the victim's heirs would be the ones responsible for pursuing justice. Maybe they wouldn't diligently pursue justice and a murderer would be let go. I think in my theory, and Rothbard deals with this by saying that people would designate in their wills how they would like, if they're murdered, in the extremely rare case that they're murdered, how would I like personally for that murder to be dealt with? In my theory, I've talked about this on the show before, but I think that there would be competing dispute resolution systems, and you would pay a premium to a certain company, and they would represent you. Well, it's not, maybe you would hire a private bar attorney, but you would pay a premium to a dispute resolution service, and at least you'd be their client. And there's different, maybe you would be interacting, and I've talked about this a lot, so I won't dwell on it, but maybe there would be someone who wronged you would be from a different dispute resolution company. Well, there's ways for them to interact with each other in different forums that are prescribed for handling when Patrick McFarland's resolution service and Rothbard's resolution service, well, they've had cases together before, so there's something already in place for resolving a dispute when one client from one company is represented by, or when one client is represented by one company and when a different litigant is represented by a different company. And, all of this can be dealt with. And moreover, it has been dealt with throughout history. But moreover, my theory is that when you pay this premium to your dispute resolution agency and you're murdered, it goes on to either maybe onto your heirs to pursue the conviction, or moreover, I think it would be the resolution service that you pay a premium to. And just as with an insurance contract, there's a duty of good faith there. There's implied contractual and agency tort duties that insurance companies have to their insured. Now I can rely on my own expertise in this. But I imagine similar duties of good faith would be imposed upon, they'd be held to, is the dispute resolution agency that you pay a premium to. And there would be a bunch of law on that. And you can even sue your insurance company, and apologies, this is kind of an aside, but you can sue your insurance company if they fail to settle a claim for you properly in good faith. So let's say you get into a car accident and you're hit by someone who does not have insurance. Well, let's say you have American Family Insurance. You have in Wisconsin, every single person is required, in every car insurance policy, there's required to be uninsured motorist coverage, which covers you in the event that someone who's uninsured hits you. So let's say you are hit by someone who's uninsured. You have a whole bunch of damages. Your leg is messed up. It's messed up forever. You lose your job, or you have a traumatic brain injury and you're no longer able to be a lawyer. Well, if it comes apparent that the insurance company has investigated this accident and has come to the conclusion that they are going to have to pay out their entire premium, their entire policy limits, which is probably $300,000, and they wait and they bring you to the eve of trial before they distribute that $300,000 and make you go through an entire litigation process, that's bad faith. If they knew the whole time that your injuries would require them to pay out their policy limits. Well, to make an analogy, I think that if you pay a premium to a dispute resolution agency and they failed to prosecute a case on your behalf in which you have been murdered, there would be a case of bad faith that your estate could bring against this dispute resolution company. Not to mention all the bad business that would get. There'd be agencies like the Better Business Bureau that would grade different businesses. And so you can just imagine all these different things that could come about. And in fact, Rothbard mentions this at the end of, the second paragraph on page 86. The deceased indeed could provide in his will for, say, a crime insurance company to which he subscribes to be the prosecutor of his possible murderer. So the final paragraph on page 86 is where Rothbard starts to advocate the fact that in a libertarian society, if someone wrongs you, a criminal wrongs you, and they are destitute, well, then you can enslave them. The victim may enslave the criminal until the debt to the victim is paid off. So let's read through his whole thought process here. He says, if then proportionality sets the upper bound to punishment, how may we establish proportionality itself? The first point is that the emphasis in punishment must be not on paying one's debt to society, whatever that may mean, but in paying one's debt to the victim. Certainly, the initial part of that debt is restitution. This works clearly in cases of theft. If A is stolen $15,000 from B, then the first or initial part of A's punishment must be to restore that $15,000 to the hands of B, plus damages, judicial and police costs and interest foregone. Suppose that, as in most cases, the thief has already spent the money. In that case, the first step of proper libertarian punishment is to force the thief to work and to allocate the ensuing income to the victim until the victim has been repaid. The ideal situation then puts the criminal frankly into a state of enslavement to his victim, the criminal continuing in that condition of just slavery until he has redressed the grievance of the man he has wronged. See, I don't know if I agree with this. To draw a different parallel so libertarians are always accused of agreeing with Rothbard on 100% of everything because he is our baby Jesus. But I don't know if I agree with this, because according to the Rothbard-Evers libertarian theory of contract, you can only make pledges to alienable property. That is, to force performance in a contract. As in the current system today, you can't sue for directed performance, which is to force one side of the contract to perform their side of the bargain. And that's because your human will in control of your own body is not alienable. It's inalienable. You can't get rid of it. That's why I don't think that you can, in a libertarian system, in a libertarian society, it's impossible to, and I hope this isn't a straw man, is that maybe Rothbard's counter argument would say, well, you're not trying to control the will of the wrongdoer, of the criminal, when you enslave him. You're just trying to get his alienable property, which would be his wages, kind of like a wage garnishment thing. I think, frankly, that would be the only way really to do this. And it's a huge problem because criminals usually don't have jobs. They're usually not working. They don't have any wages or any property that you can attach a lien to or wages to garnish. And frankly, it's a huge problem that you grapple with. The reality of the legal system is, okay, you might have a good case in small claims court or in a civil case, and this is why insurance companies are awesome. But you might have that case or that claim, but good luck collecting on it because this dirtbag doesn't have any property. He doesn't have a job. There's no alienable property to go after. And so this is where I depart from Murray Rothbard. And I have an episode called Small Claims Court Sucks. And I don't recall the number of it, but that's where I really talk about my experience litigating in small claims court and how difficult it is to actually collect on a judgment from someone, because no one works, of course, and no one who's being sued in small claims court has property that you can attach a lien to. So I don't know. It's a huge problem that I don't know if insurance would cover this, is that if you buy liability insurance, but would a criminal really have liability insurance, or would they think about that? Or would the dispute resolution agency that they subscribe to, would they have a victim compensation fund for indigent clients? Or would everyone just be expected to buy property insurance or crime insurance, victim crime insurance? Maybe that's the answer. I don't really know, but certainly I don't think that enslavement, even to correct past wrongs, that runs afoul of alienability. I think you can't alienate your will, and you can't alienate someone else's will by forcing them to work, even if they have wronged someone. You're not going to have a perfect system no matter what you do. And maybe there's a creative way to deal with this. I've mentioned some. But let's see what Rothbard says. Maybe he'll justify that. So he says, we must note that the emphasis of restitution-based punishment is diametrically opposite to the current practice of punishment. I mentioned this earlier. What happens nowadays is the following absurdity. A steals 15,000 from B. The government tracks down, tries and convicts A, all at the expense of B as one of the numerous taxpayers victimized in this process. Then the government, instead of forcing A to repay B or to work at forced labor until that debt is paid, forces B, the victim, to pay taxes to support the criminal in prison for 10 or 20 years' time. Where in the world is the justice here? Well, he has a point here, even if I disagree with the enslavement. But the victim not only loses his money, but pays more money besides for the dubious thrill of catching, convicting, and then supporting the criminal. And the criminal is still enslaved, but not to the good purpose of recompensating his victim or recompensing his victim. So maybe his counter argument too would be, well, if you don't think that we can enslave the wrongdoer, the criminal wrongdoer, then you must not believe in prisons because that's a certain kind of enslavement. Okay, maybe I don't believe in prisons then, but let's, unless I'm sure Rothbard wrote about this, but let's resurrect his ghost and have a conversation. So on page 87, after this, Rothbard kind of highlights the history of how things didn't used to be this way. It used to be that the criminal law was for compensating victims and not necessarily engineering society or for being a utilitarian-based model. And he says, for instance, in medieval Ireland, the king was not the head of state, but rather a crime insurer. If someone committed a crime, the first thing that happened was that the king paid the insurance benefit to the victim and then proceeded to force the criminal to pay the king in turn. Restitution to the victim's insurance company being completely derived from the idea of restitution to the victim. In many parts of colonial America, which were too poor to afford the dubious luxury of prisons, the thief was indentured out by the courts to the victim, where there to be forced to work for his victims until his debt was paid. This does not necessarily mean that prisons would disappear in the libertarian society, but they would undoubtedly change drastically, since their major goal would be to force the criminals to provide restitution to the victims. I don't know. And going back to my comments, disagreeing with Rothbard on the slavery for criminal wrongdoers issue, I don't know. Maybe it's I'm from the right, but maybe it's the bleeding heart in me that says I don't think it's a slippery slope to enslave criminal wrongdoers, even if it's in the effort of compensating the victims of their crimes. But I'd say the vast majority of criminal wrongs would be shoplifting. So maybe this period of enslavement wouldn't be too long, and so perhaps it would be manageable unless you really get into some major accounting fraud or some white-collar crimes, but you would assume white-collar people would have a larger earning capacity. And moreover, where would these people work, and who would employ a criminal wrongdoer to provide for this restitution? I don't know. I think there's a lot of problems that would confront this that you'd have to kind of deal with. But Rothbard also mentions how in the Middle Ages, generally restitution to the victim was the dominant concept of punishment, only as the state grew more powerful, and I think this is after the Norman invasion of England, did the governmental authorities encroach ever more into the repayment process, increasingly confiscating a greater proportion of the criminal's property for themselves and leaving less and less to the unfortunate victim. Indeed, as the emphasis shifted from restitution to the victim, from compensation by the criminal to his victim, to punishment for alleged crimes committed against the state, the punishments exacted by the state became more and more severe. As the early 20th century criminologist William Thallick wrote, it was chiefly owing to the violent greed of feudal barons and medieval ecclesiastical powers that the rights of the injured party were gradually infringed upon, and finally to a large extent appropriated by these authorities, who exacted a double vengeance indeed upon the offender by forfeiting his property to themselves instead of to his victim, and then punishing him by the dungeon, torture, the stake, or the gibbet. But the original victim of wrong was practically ignored. Or as Professor Schaefer has summed up, as the state monopolized the institution of punishment, so the rights of the injured were slowly separated from penal law. And I've talked about this in the show in the past to direct you to my episodes on the Magna Carta and the jury trial. So the real Magna Carta is episode libertyweekly.net/58. I've talked about this in Anarcho-Capitalism and the Germanic Folklaw in episode 97. Roots of the Germanic Folklaw on episode 96. So libertyweekly.net/9796. And Lysander Spooner. There's an episode for that too. Lysander Spooner on jury nullification, libertyweekly.net/56, and realities of the U.S. justice system, libertyweekly.net/105. So those are some show notes for you. I'll try and remember those for the show notes page. So then Rothbard kind of turns again and says that, well, there are some things that just cannot, some intangibles that just cannot be returned to the victim, that cannot be paid in restitution. And this would be maybe the loss of a leg, the loss of certain body parts, the loss of subjectively valued things. And I think in our current system, this, at least in the civil law, is left to the jury, and it's usually only compensated in terms of monetary gain. But Murray Rothbard talks about how there used to be liquidated damages clauses in the Anglo-Saxon times concerning the loss of certain body parts. So I covered this in the Germanic Folklaw episodes that I just cited for you in the show notes page, but it's really interesting. The loss of a tooth is, I don't know, 5 shillings or 5 pence or whatever the unit of currency was at that time. The loss of an arm is a certain extent, but there were also classes too. And so if you were a free man, it was, your body parts were worth more than if you were a serf or something like that. So he says, though, that these liquidated damages are wholly arbitrary, which I think is fair. And they're objective damages, so they don't get into the subjective state of it. But let's see if he takes this in a direction of, well, an eye for an eye and a tooth for a tooth, literally, which he doesn't. But he goes on to say that, well, if we're talking about proportional punishment, it's not just that the criminal who stole $15,000 shouldn't just have to pay the $15,000 back that he stole, but a proportional punishment would also make the criminal pay $15,000 of his own money to the victim. He says, let us return to the theft of $15. Even here, the simple restitution of the $15,000 is scarcely sufficient to cover the crime, even if we add damages, costs, interest, etc. For one thing, the mere loss of the money stolen obviously fails to function in any sense as a deterrent to future such crime, although we will see below. So, I mean, the point he's making is that if all the criminal has to do is pay back the $15,000 that he stole in the first place, well, that's not a deterrence, because if you steal something, then you'll just have to give it back, and then you're free to go. But then, if we say that the criminal must lose the rights to the extent that he deprived the victim, then he must pay the $15,000 on top of the $15,000 that he stole. Then Rothbard says we may say that the criminal must pay double the extent of theft, once for restitution of the amount stolen, and once again for loss of what he had deprived another. I think this only works in this immediate example. Let's say, like, you're breaking into someone's house and you don't take any money or anything, but you destroy their property. Well, you should have to pay for the destroyed property, but I don't know if that necessarily means that you should pay double the value of the property that you destroyed, according to his logic here. But to carry on, in the next paragraph and at the top of page 89, Rothbard states that, well, he didn't just steal the $15,000 from the victim, he also put the victim into a state of fear and uncertainty as to how far the victim would be deprived of his own resources, of his own property. But the penalty levied on A is fixed and certain in advance, thus putting A, the wrongdoer, in far better shape than was his original victim. So that for a proportionate punishment to be levied, we would also have to add more than double, so as to compensate the victim in some way for the uncertain and fearful aspects of his particular ordeal. And then he says, well, this extra compensation definitely isn't arbitrary, but it's impossible to say exactly. We would have to have a jury figure that out, or something, a mediator or something, to hear both sides and to come up with a solution. And that's actually how it works in the Japanese legal system. Furthermore, Rothbard states that in the question of bodily assault where restitution does not even apply, we can again employ our criterion of proportionate punishment so that if A is beaten up B in a certain way, then B has the right to beat up A or have him be beaten up by judicial employees to rather more than the same extent. See, I was wondering if it would go in the eye for an eye, tooth for a tooth direction. I don't know about that. I just don't. It might be the case that I don't think the average victim would actually like to see physical punishment be distributed or carried out to the victims. I don't know if I would necessarily, maybe this would exist and be justified in a libertarian system, but I think it's kind of barbaric. And that's not necessarily a substantive argument against it, but I don't know. I just don't know if I'm comfortable with that. And I don't think that that kind of model would survive in the market in this day and age. And maybe that's the best argument against it. And just as he stated before, Rothbard says, well, the victim can choose, any way for the criminal wrongdoer to make the victim whole. He could either accept money in terms of evading punishment for the crime, or the victim could have the criminal beaten up as severely or a bit more, or hire someone else to do it for him to beat this person up. I just don't think there's no way of assuring that the victim, or there's no way of assuring that the criminal would be beaten up to the same point that the victim was. I don't know how you would actually measure that. Would you measure the size of bruising, or how could you measure the exact force with which a hand, a fist punched someone else? I don't know about that, or injuring them in the exact same way. Maybe that's missing the forest for the trees here, but I don't think that's possible or realistic. The victim then has the right to exact punishment. I'm sorry, to go back. Nothing, and this is what clients or victims that I've worked with in my legal career will say, is that I would specifically in my personal injury practice, I've had clients, generally people come in and they say, I'm not out to get rich here. I'm not about that. And people generally aren't. They're not out to get rich. They say, whatever money I get from this lawsuit, I would gladly pay back to have this never happen again. And unfortunately, that would be the truly just result of a lawsuit, but that's impossible. And I don't think that what Rothbard is proposing here, or arguing for, is possible. I don't think it's realistic, but it's an imperfect, you're grappling with something that's impossible. And the best way to do this, I think, according to libertarian theory, I think this retribution in terms of physically inflicting violence or enslaving the criminal, I don't know if I agree with it. I don't think it has the potential to turn bad. But moreover, I don't think it would be popular in the market. And maybe it would, but I think it would get a lot of bad press from certain parts of our society. And Rothbard goes on to reiterate the fact that, yes, the victim can choose the proportionality of the punishment and the manner of the punishment and the restitution. And I think that this would add something to the equation, though, is that, well, we can't make it so that this never happened, but we can give the victim an opportunity to show mercy and perhaps gain something of their own self-actualization from the process of showing mercy. And I think there's benefit to that. And if you give victims that ability to show mercy and come to terms with it themselves, they can grow in a certain way and get some kind of closure for themselves. If not, if they can't make it so that the event never happened, at least they could get the closure. In the next segment, Rothbard takes on the idea of taking the law into their own hands, or vigilante justice. Would the victim or a friend of the victim be allowed to exact justice personally on the criminal? He says the answer is, of course, yes, since all rights of punishment derive from the victim's right of self-defense. Again, they condition you so much in law school, and this freaks me out reading this too, because they condition you so much in law school that the reason why we have due process and the reason why we have the judicial system is to prevent vigilantism and vigilante justice, because if we didn't prevent vigilante justice, we would just descend into chaos and anarchy, and everyone would lose their rights and the world as we know it would end. So you'll have to forgive me for, I'm kind of sounding like a stodgy pragmatist here in this episode. I don't know if I like it. I see that Rothbard kind of rebuts all the things I've picked, the bones I've picked with him a little bit in the back end of this chapter. So we'll see how he addresses it. But he says, yes, since all rights of punishment derive from the victim's right of self-defense, in the free market society, the victim will generally find it more convenient to entrust the task to the police and court agencies. And I think that's a fair point, because if you don't entrust it to the professionals, you're taking on a personal risk to yourself. It's a gamble of the fact that, okay, well, you might get your own vigilante street justice, but you're risking that you might die or be even more horribly injured. But Rothbard says, suppose, for example, that Hatfield murders McCoy. McCoy then decides to seek out and execute Hatfield himself. This is fine, except that just as in the case of the police coercion discussed in the previous section, McCoy may have to face the prospect of being charged with murder in the private courts by Hatfield. The point is that if the courts find that Hatfield was indeed the murderer, then nothing happens to McCoy. In our schema, except public appropriation, or expect public approbation for executing justice. So he's saying then that if you take the law into your own hands without proving in the court of law that you were wronged, then you might be subject to criminal process yourself after the fact. But if it turns out that there was not enough evidence to convict Hatfield for the original murder, or if indeed some other Hatfield or some stranger committed the crime, then McCoy, as in the case of the police invaders mentioned above, cannot plead any sort of immunity. He then becomes a murderer, liable to be executed by all the courts at the behest of the irate Hatfield heirs. Hence, just as in the Libertarian Society, the police will be mightily careful to avoid invasion of the rights of any suspect unless they are absolutely convinced of his guilt and willing to put their bodies on the line for this belief. So also, few people will, quote, take the law into their own hands unless they are similarly convinced. Well, I think, it's one thing to be personally convinced of something, and it's another to prove it in court. So maybe that's my take on it. But spoken about earlier in this book was, and a big part of Rothbard's theory of the law is that police shouldn't have immunity for wrongfully prosecuting someone. Is that if police suspect someone of a crime and they hold this person on bail for 2 weeks or 3 weeks or months or a year pending trial, then the person is later exonerated, or their conviction is not upheld, they're declared innocent through the judicial process, then the police would have to either go to jail for falsely imprisoning someone, or they would have to pay restitution to that person that was wrongfully accused for being in prison. I think it's certainly interesting. It could be a huge burden to dispute resolution agencies if that was the case. Maybe according to libertarian legal theory, that is the case, but it's hard to prove stuff. Even if someone did end up doing the crime, it doesn't mean you can meet the burden of proof and convict them. The burden of proof is pretty high, and I would suppose that the burden of proof would be similarly high in a libertarian dispute resolution order. But so Rothbard concludes that society would frown on this vigilantism, and that it would be a lot safer for victims to go to the courts and go through the quote unquote proper processes. So, and it would be done better that way. So it'd be highly unlikely that people would turn to that. And I think that's a fair statement that I wouldn't necessarily disagree with, but, in Rothbard sufficiently, I think, convinces me that if someone there's a lot of risk in there's not just risks of death to yourself in taking the law into your own hands, but there's also risk of subsequent prosecution that would effectively deter people from doing it. And moreover, in the current system, lots of people take the law into their own hands. And this is mostly we see with gang violence and with drugs and things like that. So just to say that something is allowable in a libertarian legal system doesn't make it invalid. In fact, de facto vigilantism is allowed in our system because the police just can't grapple with it and enforce against it. So Rothbard, in the final few pages, I think the final 5 pages of this addresses my argument about my concerns with an eye for an eye or a tooth for a tooth, this retribution-based theory of punishment. He says retribution is in bad repute among philosophers who generally dismiss the concept quickly as primitive or barbaric, just as I did. I guess I'm a token. And then race on to a discussion of the two other major theories of punishment, deterrence and rehabilitation. So I don't know. I believe in compensating in this retribution, restitution based. I don't know. I think restitution is different than retribution based system. However, I also, I don't know if I'm too concerned with deterrence, but I am concerned with rehabilitation. And I think that a dispute resolution agency would have good rehabilitation options for their clients. And of course, Rothbard states that simply criticizing something as by labeling it barbaric isn't, it's not a good objection to it. It's not an argument, and I'll cop to that. However, it is possible that in this case, he said the barbarians hit on a concept that was superior to the more modern creeds. So he says Professor Hart describes the crudest form of proportionality, such as we have advocated here. The notion, this is a quote, the notion that what the criminal has done should be done to him, and wherever thinking about punishment is primitive, as it often is, the crude idea asserts itself. The killer should be killed, the violent assailant should be flogged, or whoever amputates someone's arm should have their arm amputated, yada, yada, yada. But again, primitive is scarcely a valid criticism, and Hart himself admits that this crude form presents fewer difficulties than the more refined versions of the proportionality retributivist thesis. His only reason criticism, which he seems to think dismisses the issue, is this quote from Blackstone. There are very many crimes that will in no shape admit of these penalties without manifest absurdity and wickedness. Theft cannot be punished by theft, defamation by defamation, forgery by forgery, adultery by adultery. But these are scarcely cogent criticisms, Rothbard says. Theft and forgery constitute robbery, and the robber can certainly be made to provide restitution and proportional damages to the victim. There is no conceptual problem there. Adultery in the libertarian view is not a crime at all, and neither is defamation, which I agree with that. Let us then turn to the two major modern theories and see if they provide a criterion for punishment which truly meets our conceptions of justice, as retribution surely does. Sure, retribution does, but I don't think Rothbard, at least to this point, is not addressing the theory of barbaric and barbarity. I think that, it's not an argument just to call it barbaric and to walk away, but I do think it is it's at least a criticism that makes sense, because, and that's why I say I don't think it would be, from a functional level, I don't think it would be popular in the marketplace to do this, because I don't know if it gets on camera and people see this and see how brutal a dispute resolution service is. They wouldn't want to be known as the mobsters that will kill criminals. And furthermore, if it's a possibility that someone might be convicted, and wrongful convictions will happen, I don't think that certain subscribers to dispute resolution systems would elect to be subscribed to a system in which case they could be wrongfully convicted and have the crap kicked out of them, or have their arm amputated, or going on and on. So he just kind of knocks down the principles, the alternative theories, instead of explaining why a retribution theory wouldn't be barbaric. He knocks down the other theories, which I don't think are good theories. I would agree with Rothbard. I don't think they're good theories, but he says deterrence was the principle put forth by utilitarianism as part of its aggressive dismissal of principles of justice and natural law, which I would agree with, and the replacement of these allegedly metaphysical principles by hard practicality. The practical goal of punishments was then supposed to be to deter further crime, either by the criminal himself or by other members of the society. But this criterion of deterrence implies schemas of punishment, which almost everyone would consider grossly unjust. For example, if there were no punishment for crime at all, a great number of people would commit petty theft, such as stealing fruit from a fruit stand. On the other hand, most people have a far greater built-in inner objection to themselves committing murder than they have to petty shoplifting, and would be far less apt to commit the grosser crime. Therefore, if the object of punishment is to deter from crime, then a far greater punishment would be required for preventing shoplifting than for preventing murder, a system that goes against most people's ethical standards. As a result, with deterrence as the criterion, there would have to be stringent capital punishment for petty thievery, for the theft of bubblegum, while murderers might only incur the penalty of a few months in jail. I think that's compelling. Also, in my own experience in the criminal justice system, my wife likes to watch Law and Order, and I hate that show. It's just so statist and unrealistic. But I digress. This utilitarianism has really moved to data, as in data is the new oil, a data analysis based kind of model where instead of actually focusing primarily on the circumstances of the crime, we will do a pre-sentence investigation where we put the convicted criminal through a whole bunch of personality tests and evaluations where we reduce all of their properties basically to statistics and number scale gradings, and based off of that number we then decide what the sentence should be or what the bail amount should be. And this happened mostly, and it's not that this reducing a criminal to numbers by sending them through programming. It's not necessarily that that's the only way that we decide what the punishment should be or how high the bail should be, but it certainly is a substantial factor in it. And I would say it's based around that, even more so than the actual circumstances of the underlying offense. So I think, Rothbard knocks down deterrence there. He says, similarly, a classic critique of the deterrence principle is that if deterrence were our sole criterion, it would be perfectly proper for the police or courts to execute publicly for a crime someone whom they know to be innocent, but whom they had convinced the public was guilty. The knowing execution of an innocent man, provided, of course, that the knowledge can be kept secret, would exert a deterrence effect just as fully as the execution of the guilty. And yet, of course, such a policy, too, goes violently against almost everyone's standards of justice. So in some ways, Rothbard is saying that, well, blood is on the hands of these other theories of punishment as well. So libertarian retribution in terms of eye for an eye, tooth for a tooth isn't too barbaric in terms of what could be justified under these other theories of punishment. The fact that nearly everyone would consider such schemes of punishments grotesque despite their fulfillment of the deterrence criterion shows that people are interested in something more important than deterrence. What this may be is indicated by the overriding objection that these deterrent scales of punishment or the killing of an innocent man clearly invert our usual view of justice. Instead of the punishment fitting the crime, it is now graded in inverse proportion to its severity, or it is meted out to the innocent rather than the guilty. In short, the deterrence principle implies a gross violation of the intuitive sense that justice connotes some form of fitting and proportionate punishment to the guilty party and to him alone. The most recent, and I'm kind of reading this because I think it's important that Rothbard's critique of deterrence and these other principles, theories of punishment be heard, because this is the winning creed currently in our justice system. He says the most recent, supposedly highly humanitarian criterion for punishment is to rehabilitate the criminal, and I would be for rehabilitation. But he says old-fashioned justice, the argument goes, concentrated on punishing the criminal either in retribution or to deter future crime. The new criterion humanely attempts to reform and rehabilitate the criminal. But on further consideration, the humanitarian rehabilitation principle not only leads to arbitrary and gross injustice, it also places enormous and arbitrary power to decide men's fates in the hands of the dispensers of punishment. So before we even get into Rothbard's example, say, one thing that I've noticed about the this reforming or rehabilitating criminals is that usually the rehabilitation is offered as a carrot on a stick to people to entice them to plead out to offenses. And, they're not necessarily guilty. If they're facing 6 years or a criminal conviction on their record, they would much more gladly take the diversion program to expunge this criminal conviction or the charge, as opposed to taking their chances with the jury. I think it does, the way that rehabilitation is played out in the system isn't just, I don't think, because it entices people to plead. Thus suppose, but here's Rothbard's example. Thus suppose that Smith is a mass murderer while Jones stole some fruit from a stand. Instead of being sentenced in proportion to their crimes, their sentences are now indeterminate, with confinement ending upon their supposedly successful rehabilitation. But this gives the power to determine the prisoners' lives into the hands of an arbitrary group of supposed rehabilitators. It would mean that instead of equally under the law, an elementary criterion of justice, with equal crimes being punished equally, one man may go to prison for a few weeks if he is quickly rehabilitated, while another may remain in prison indefinitely. Thus, in our case of Smith and Jones, suppose that the mass murderer Smith is, according to our board of experts, rapidly rehabilitated. He is released in 3 weeks, to the plaudits of the supposedly successful reformers. In the meanwhile, Jones the fruit stealer persists in being incorrigible and clearly unrehabilitated, at least in the eyes of the expert board. According to the logic of the principle, he must stay incarcerated indefinitely, perhaps for the rest of his life. For while the crime was negligible, he continued to remain outside the influence of his humanitarian mentors. And this is certainly a good argument advanced on behalf of Rothbard. In the way that I've seen things play out, it's not necessarily this rehabilitation. No one expects criminals who go to prison to be rehabilitated in our current system. I think that the rehabilitation usually comes in programming that will divert frequent flyers or recurring offenders from doing jail time or being convicted, or will reduce your sentence if you do this programming XYZ. So Rothbard goes off a bit more about this rehabilitation, and I think we get the point, generally speaking. And Rothbard continues with a bunch of meaty quotation passages that I won't read at length here, but they're on page 94 to the end of the chapter, page 96, stating that, well, if it is so tyrannical for someone to put you in jail, kind of 1984 George Orwell wrongthink kind of idea where we're going to determine what it means to be reformed, and we'll keep you in jail and do this against your will until you are what we deem to be reformed, and then you can rejoin society. How tyrannical and unjust that is. I don't know if that completely goes against my conception of what reforming would be, or trying to reform criminals. I think I like to think that it's more of a gentle approach in what dispute resolution systems, how they would be focused on in the future, would be reforming criminals. But I definitely see Rothbard's point when it is a state-based apparatus that is imposing this reformation on criminals. So in a libertarian system, maybe it might be different, where there would be charities, or there would be an option of a dispute resolution agency to, or perhaps victims to choose what the offenders and convicted offenders have to do for programming. And I certainly think that all of these theories of justice and punishment, they are all, it's not that our system is completely made up of one or another. There's elements of all of these, and even elements of restitution in the system, even though it's the smallest part probably of the criminal law in general. But it's not like it's one thing or another, or that an entire prison sentence is mainly based off of reforming the individual. I don't think that's the case. I think it has to do a lot with trying to get people to plead to things or accept lesser punishments and programming in return for either disposing of a charge on the criminal complaint, or for, getting them to plead out to a deal so that the DA can move on with their caseload. But Rothbard, he ends the chapter on page 96 by knocking down this idea of reformation approach, how retribution remains as our only just and viable theory of punishment, and equal treatment for equal crime is fundamental to such retributive punishment. The barbaric turns out to be the just, while the modern and the humanitarian turn out to be grotesque parodies of justice. So maybe throughout history, as it plays out, the eye for an eye, tooth for a tooth theory ends up being the least tyrannical. But I think that us modern humans have gotten so indoor cat and so used to not seeing violence in our daily lives or being witness to any of that. And I don't think that the literal someone battered me, so I'm going to have the court authorities beat the crap out of him. I don't think that would fly in a libertarian legal order on the market. And maybe it would in different cultures. I don't know. But the average American, I don't think would really go for that. Even in the red counties, in the deep red flyover counties, flyover states, flyover communities, if you will. So, well, I hope you enjoyed my commentary on Murray Rothbard's, I think that's, chapter 13 of The Ethics of Liberty. Perhaps we'll dive into Bruce L. Benson's commentary on restitution and how we could go to a more restitution-based society. But I'm more inclined to kind of skip to a different topic and maybe return to Bruce Benson's piece on the restitution. But so there, as I'm closing up here, there's been a lot of talk about the Revolution 2.0 with Jacob Hornberger, with him not returning, but running for the LP presidential nomination. I think it's pretty damn exciting. I think we can learn a little bit more about what he's about because he did an interview with Keith Knight, and I'm going to be putting that as the next episode next weekend for you guys all to listen to. Looking forward to coming back and resuming publishing with more regularity here. I hope that I didn't lose too much of my audience in this little hiatus here. Looking forward to kind of establishing that regular publishing schedule and to having you guys listen to Keith Knight and his wonderful interviews if you're not familiar with him yet. But I think you will be. So again, as I left for a little bit, I lost some Patreon subscribers, which has pushed me back into the red in terms of operating cost. I have a whole slew of archived content at patreon.com/Liberty Weekly. You'd also get access to the 2 unreleased episodes that I didn't want to drop in the main feed during the hiatus. So that's there as well. I'm looking forward to dropping more Patreon bonuses. If you have any ideas for Patreon bonuses that would entice you to become a patron, please send me an email at patrick.mcfarlane@libertyweekly.net. It's a rather long email address, but my last name is MacFarlane. So hit me up there. Also, send me your thoughts on what you think that you would like to see in the show content. I'm kind of wedded to this idea of really doing deep dives like this into libertarian legal theory and really getting into that niche. But we'll see. I mean, I frankly, I don't think that it's my skill set to have an entertainment podcast or I feel like I'm a good interviewer, but that also doing interviews and trying to schedule them is too much for me right now. And I should be reading this stuff anyways and building my portfolio and repertoire, so to speak, as well. So I think that's about it. Liberty Weekly show notes at libertyweekly.net/127. Also check out the Liberty Weekly podcast. It's my B show. It's at anchor.fm/Liberty Weekly. That's Liberty Weekly, WEAKLY, Liberty, Weekly. And I think that was a clever name. So I publish that with more regularity, and it's not all about liberty. It's more off the cuff. I find it enjoyable, and it's attracting a listenership. So anyways, good to be back. Please reach out to me, hit me up on all the social medias, usually not Twitter, that's gone, but facebook.com/Liberty Weekly, BitChute, Minds, all that kind of stuff. So hit me up and we'll talk to you later next week.
In the early days of the internet, radical libertarians were scattered, lonely, and faceless. Without direction, they resigned to scour the web, sifting through content providers in a wasteland plagued by YouTube demonetization, Facebook jail, and covert internet censorship. But then, in 2017, the Libertarian Union was formed. Finally, the average Joe Libertarian could find a thriving community of independent podcasters and content providers, all in one convenient location. At Libertarian Union, we'll always have the latest news, interviews, discussions, and even movie reviews. With hundreds of episodes and more added all the time, you'll always find something fresh at libertarianunion.com.